Hey, everyone. We're going to get started. We have a lot of material to cover today. And if we don't get started, we're not going to get you out on time. Or if we get you out on time, we're not going to be able to cover all the material. Couple things. First of all, I want to apologize for the fact that we've changed the topics so many times as part of this presentation. We did that because it's not our fault. The government and regulatory agencies keep changing things. And when we looked at what's important to the nonprofit sector, we kind of felt that things needed to be talked about today that weren't originally part of our plans 4 months ago when we put this together. So if you came here to learn about mergers and acquisitions, sorry, we're not going to be covering mergers and acquisitions. We have some 990 issues that came about because of Trump, and we're going to be kind of talking a little bit about that. We feel that's a little more relevant. If you were interested in the budget and the impact of the budget, nope, that's not being covered today either. We changed it because we have some new sexual harassment regulations that have come out that we think are a little bit more important and timely, since those have to be put in place by October. So again, we do apologize that we've kind of changed some topics around. Hopefully the topics today that we've put in place are a little more relevant. There's an outline of what we're going to be talking about on page 2 of the presentation. We're going to try to hold to the schedule. Hopefully that'll happen, but we'll see. Also in your folder, so you have 2 presentations, by the way. You have a folder, that's our folder, the Cerini Associates folder. In there is where you'll find something that looks like this, which is all of the slides other than the first presentation, which David is doing. David's is in his own book. David likes to bring his own book. He also tries to make his book bigger than our book every year. I don't know. There's something probably deep-rooted in there. I'm not sure. But in the folder, you'll also see we gave you some information about some of the seminars, other things that we're doing that are coming up. We have a Let's Imagine event here on Thursday, September 27th. That event is going to be, we have the winners of the Imagine Awards from last year coming in, and they're going to be on a panel, and we're going to be talking about what makes them effective and stuff. So anybody who's attended the Imagine Awards, they should definitely come and hear from the winners. Anybody who hasn't attended the Imagine Awards, what's wrong with you? In terms of other things, also in the folder is an evaluation form at the end of the presentation. Please, 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 and I'll remind you at the end, fill out the evaluation form. It's important because we really need to know how we're doing. If there are topics you want us to talk about in the future, we want to know what those topics are, because it's important for us to make sure that we're getting you relevant information. Just put them down. We'll put them on our list of things that we're going to talk about, and then we'll change them last minute. So that's awesome. Also, if anybody needs accounting, continuing professional education, there's a little place up here where you can kind of put in for that. But also, you have to go outside and sign in, time out, so that you can get the certificate mailed to you or emailed to you. So again, if anybody needs continuing professional education, please let us know. We're doing this as a webinar also, so it's both in-person webinar. The people on the webinar can ask questions. Christina is our person who's going to be handling all of the questions from the webinar. If anybody has questions as we're going through, I'll actually be standing in the back with the mic, so just raise your hand and I'll come running over with the mic so you can ask the question. We need the microphone because that connects into the webinar so the people on the webinar can hear the questions too. That's the mic that I'm going to be running over with. So please wait for the microphone so that people can hear it. I think I covered all of the pre-stuff that I needed to cover. So we're going to get into the presentation, and our first speaker probably needs no introduction, but David Goldstein from Certilman. He's going to come up and give us a little insight into what's happening with the 990 and the whole Trump issue.
Good morning, everyone. Okay, so before I get going, just sort of by way of introduction, just to set the stage, want to clarify that though we're going to be talking about something that is occurring in something of a political context, I want to emphasize that the emphasis in my presentation is not going to be political at all. In fact, I think, as you're going to see, I'm less interested in President Trump and more interested in what the petition that the Attorney General filed on June 14th means for all of us in the nonprofit sector, particularly directors and officers. We should also note that this is a petition that's pending in Supreme Court. It's not yet a decision by a court or a settlement. And finally, you'll see once we get into the petition in detail, in the PowerPoint, I used lots of direct quotes, and you'll see quotation marks. And I did that intentionally because I wanted you to get the flavor directly of how the petition positioned things. And you've also got paragraph references to the petition. The petition itself is in tab 2 of your materials. And you'll see in the slides that there are section references, paragraph references. Okay, so the Attorney General's action against the Donald J. Trump Foundation and its board, what does it tell us about nonprofit compliance and directors and officers' duties and liabilities? And that's going to be our focus. And let's start right up top with what you'll see on the front page of the petition. Who are the respondents? Who basically who are the defendants in this action? It's Donald J. Trump, Donald J. Trump Jr., Ivanka Trump, Eric Trump, and the Trump Foundation. And I'm particularly interested, and I'm going to focus on the 3 Trump children, Don Jr., Ivanka, and Eric. And so I'm using Broadway font in this slide because if we were working for a Hollywood movie studio and the Trump Foundation saga was the subject of our movie, would the foregoing list of respondents work as our lead credits for the stars of this movie? And that's a leading question. And so it's Don Jr., Ivanka, and Eric. And what's wrong with this picture? Why wouldn't this work as our credits? And the answer is that 3 of the primary star players didn't appear in the movie. So when you read through the petition, what you're going to notice is that aside from being targets, Don Jr., Eric, and Ivanka are absent. They weren't involved in the activities that gave rise to this petition by the Attorney General, this enforcement action, and therein lies the lesson, and we'll go into that a little bit more. So you'll see in the petition, and I want to call to your attention, a reference to a particular section of the Not-for-Profit Corporation Law. It's 112A7. And that section says that the Attorney General can maintain an action to enforce any right given under this chapter, under the Not-for-Profit Corporation Law, to members, a director, or an officer of a charitable corporation. The Attorney General shall have the same status as such members, director, or officer. So that's kind of interesting because I think we need to kind of look at this petition and look at the statutory provision and kind of look at the inverse of this proposition. So this section says that the Attorney General can stand in the shoes of a member, director, or officer. So as we're looking through this petition, we should realize that members, directors, or officers of a charitable nonprofit have the ability to act on all of these same statutory rules, regulations, and duties and liabilities of board members. So what are the duties of a nonprofit director under New York law? And I'm going to do a quick review of those duties, and I think some of you are familiar with them. I hope actually all of you are familiar with them, but we'll do a quick review because I think that'll help us as we get to the details of the petition. So 2 fundamental precepts here. The first is that directors of nonprofits under New York law have legal duties. These are often referred to as fiduciary duties. And in fact, there can be personal liability to directors for breaching those fiduciary duties. And those three primary legal duties that a nonprofit director has are the duty of care, the duty of loyalty, and the duty of obedience. So we're going to go through those quickly, and then we're going to see how they play out in the Attorney General's petition against the Trump Foundation. And in particular, we're going to have a view to the quote, inactive directors and how those duties impacted them, notwithstanding the fact that that they were more or less not present. So the duty of care. And that requires that a director has to discharge the duties of his or her position in good faith and with the care that an ordinarily prudent person in a like position would exercise under similar circumstances. And this is codified, actually. It's right out of the law. It's in section 717A. And you have this section of the law in your materials with a number of other legal provisions that we're going to speak about today. And in plain English, this is really the board's oversight function. And it requires familiarity with the organization's finances and activities and regular participation in its governance. You've also got a summons with notice in your materials from the Healing Arts Initiative lawsuit. This was a lawsuit a couple of years ago where, and it's really, I believe, 2.5 pages. It's in your binder. When you look at it, you'll see that the defendants are the include the 9 directors being sued as individuals, and they're being sued simply for failure to maintain the required oversight, which resulted in monies being embezzled from the organization. So on that note, what board members very often ask me is, okay, we understand we have this duty, but put some meat on the bones. How do we understand what we need to do to fulfill this duty of care, this oversight responsibility? So there's a bunch of materials that you've got in your binder that will help to highlight that for you. And in particular, right from the start, responsibilities of directors of not-for-profit corporations by the Attorney General's Charities Bureau. And that's a wonderful tool. It's written for non-lawyers, and it really lays out what your legal duties are and how you can fulfill them. Similarly, you've got in your binder the Adelphi University lawsuit, a Board of Regents decision from 1997. It's about 47 pages long and goes into great detail as to how a board should and should not exercise its oversight responsibility. So I definitely recommend that for your reading when you've got an hour or two. Internal controls are critically important in board oversight, and you've got in your materials a Charities Bureau publication on internal controls, a guidance document that will help you understand how to implement appropriate internal controls. Policies and procedures should be developed by an accounting firm with familiarity with nonprofit accounting. It's not good enough to have really good policies and procedures tucked away in a drawer that nobody looks at. They need to be implemented as well. The critical role of audit oversight is something that I hope we'll have time to speak about. If not, there's some materials in your binder that address that. In my experience, not a scientific study, but where something goes wrong in a nonprofit, including, frankly, in the Trump Foundation, had there been, in every instance that I've seen, had there been appropriate oversight by an audit committee, the problem could have been prevented. And finally, our focus today, the Trump Foundation petition, will give you an excellent sense of how the duty of care needs to be implemented by a board. Second of the 3 duties is the duty of loyalty. And it is what it sounds like. A director must act in the interest of the organization, requires undivided allegiance to the organization's mission when using the power of his position or her position, or information that they may have concerning the organization. And this, as you might expect, is reflected in the rules regarding conflicts of interest and related party transactions, which are, again, very prominent in the Trump petition, so we're going to get to that. Duty of obedience. That is the least understood and most often neglected of the three primary legal duties. And the reason why is that the other two duties exist in the for-profit world, but the duty of obedience is strictly a not-for-profit corporation law concept. So what is the duty of obedience? To ensure that the organization complies with applicable laws and regulations and its internal governance documents and policies. And you might expect, you're listening to all this, that all three of these duties are going to come into play as we go through the Attorney General's petition in the Trump Foundation matter. So compliance with applicable laws and regulations is more difficult than it sounds because you've got multiple layers of laws and regulations, federal, state, and local. So here's just one example. One very fundamental law that's relevant to the Trump Foundation enforcement action is the definition of a nonprofit corporation under the not-for-profit corporation law, which is section 1025. And that requires that no part of the assets, income, or profit of the corporation inures to the benefit of an officer or director of the corporation. The Internal Revenue Code, and this is going to be a theme, the fact that the Internal Revenue Code and the New York law have very parallel provisions, protections, and exposures for directors and officers. The Internal Revenue Code has a parallel prohibition on private benefit and private inurement, and this is right off of the IRS's website, that a Section 501c3 organization must not be organized or operated for the benefit of private interests, such as the creator or the creator's family, et cetera. And you'll find provisions to this effect in the Certificate of Incorporation of nonprofits because that's something that the IRS requires to grant tax exemption. So that IRS protection becomes integrated into the state law document and now creates not only an exposure vis-a-vis the IRS, but vis-a-vis breaching your requirements under state law. And on that note, 406 of the not-for-profit corporation law is something that applies to private foundations. And there are two kinds of 501c3s. One is public charity, the one that you're probably most familiar with. And then also the other type of 501c3 is a private foundation. The Trump Foundation is the latter, a private foundation. And 406 of the not-for-profit corporation law integrates some IRS provisions into New York law, and it automatically includes a number of provisions in the Certificate of Incorporation of 501c3s that are private foundations, and so it integrates IRS protections such as the corporation shall not engage in any act or self-dealing which would subject it to tax under Section 4941 of the Internal Revenue Code. So in certificates of incorporation of private foundations, you generally see this, but even if it's not there, it's automatically included by virtue of Section 406 of the not-for-profit corporation law. So it's almost sort of like a casino effect where you've got a progressive jackpot here. When you're breaching New York law, you're breaching Internal Revenue Code provisions, federal law, and vice versa. So the other aspect of the duty of obedience is compliance with internal governance documents and policies. And the primary document there is the Certificate of Incorporation, which is the basic corporate document. It's the charter that every corporation gets from New York State that allows it to operate. It gives the corporation authority to exist and to operate going forward. It's basically a contract between the organization and the state, and your corporate purposes must be set forth in your Certificate of Incorporation. So the principle that's critically important vis-a-vis corporate purposes is that a diversion from corporate purposes, no matter how worthy, is a breach of fiduciary duty. That's one of the oversight responsibilities of the board, to make sure that your assets are used only for your purposes. And herein lies what I refer to as a Certificate of Incorporation trap, which is that the very first document that a corporation drafts and signs when it starts out is the certificate of incorporation. And it's very easy for that to also get placed in a drawer somewhere or in a file or on a computer, and people lose track of what it says. But the board does that at its peril, because the board has an ongoing duty to make sure that the activities of the corporation comply with the purposes in the certificate of incorporation. And if there's a mismatch there, there's potential liability to board members for breach of duty. There are ways to amend your purposes, and it's important to monitor those and amend those to the extent that your mission evolves. So I'm going to quickly go through some aspects of bylaws that relate to the duty of obedience, and then we're going to talk about conflicts of interest, and then jump directly to the Trump petition. So bylaws are the contract between the organization and the board, and if you've got members, between the members and the board and the organization. They're rules by which legitimate corporate decisions are made. It's critical to follow the roadmap in the bylaws, because that validates corporate decisions and protects directors from breach of duty allegations. The bylaws trap is something a little different than the certificate of incorporation trap. Bylaws are not reviewed by the state, and they're very easy to change. The board generally can change bylaws as it desires without any regulator reviewing them. And so that makes it a little too easy to do things that may seem practical and rational, but may be inconsistent with the law. So that's something to keep in mind. Bylaws also invite us to fall into the mission statement trap, which is that many nonprofits like to put their mission statement right at the top of their bylaws. And that's a rational approach because you want people to always be reminded of what your mission is. Problem with that is that, as we said earlier, the bylaws are very easy to amend. And when you amend them, you're not changing your purposes in your certificate of incorporation, and those trump anything, no pun intended, that may be in your bylaws. So a lot of nonprofits fall into the trap of, as their purpose evolves, they update their mission statement in their bylaws, but in fact, that's completely out of compliance with their purposes in their certificate of incorporation. So we want to make sure to follow the bylaws that are, the roadmap that our bylaws provide, make sure that our bylaws are consistent with not-for-profit corporation law, make sure that we have an attorney making any changes to the bylaws, again, to make sure that they're consistent with the law, and remembering that on two fronts, either failing to adhere to our bylaws or having bylaws that are inconsistent with the law are a breach of the duty of obedience. And when we make mistakes in these areas, we allow board decisions to be challenged as illegitimate and potentially invalidated, and we also set up breach of duty allegations against the board and personal liability. And so my mantra, governance, it's not rocket science. I want to mention that because I don't think anything I've said so far is unduly complicated. And if you know me, you've probably heard this story before, and I can talk about this client because they're not in the room. I certainly won't mention any names. I got hired a couple of years ago by a wonderful private foundation that funds groundbreaking medical research. And they've done tremendous work and really changed the landscape of science and medicine. And so when I met them, they went around the room and they introduced people on the board. And it turned out that a lot of the board members had worked at NASA and had very impressive resumes beyond NASA as well. And what it also turned out was that their governance was abysmal, probably the worst I've ever seen. And so, I looked at them and I said, what you all do is rocket science. What I do isn't rocket science, but it requires commitment and attention to discipline. So in all of this, including in the Trump Foundation petition, I think you'll see it's not rocket science, but if you're not paying attention, you're going to have a problem. So the Revitalization Act, which is referenced throughout the Trump petition, was signed in late 2013 and effective on July 1st, 2014. And one of the primary areas of focus of the Revitalization Act was enhancing governance, oversight, and there's that word, and accountability. And one of the primary ways that the Revitalization Act did this was by requiring a conflict of interest policy for every single New York nonprofit, no exception, in terms of mission, size, sector. It applies to religious corporations as well. So before July 1st, 2014, New York nonprofits were not even required to have a conflict of interest policy. Now, not only do you have to have one, but it's got to follow the very detailed provisions and requirements of the not-for-profit corporation law. So on that note, if you look at the third bullet point here, the sample conflict of interest policy that is put out by the Internal Revenue Service and is available on the Internal Revenue Service's website is absolutely and unquestionably inadequate and a breach of duty under New York law, because it does not meet the very detailed and heightened requirements that the not-for-profit corporation law insists on. I think what we're going to do now is skip to, we'll come back. We'll come back to conflicts and related party transactions if we have time, but I'm going to skip ahead to the Trump petition because I want to make sure that we cover this. This is slide 37 here, but I believe it's 36 in your book. So again, I'm going to remind you that you've got paragraph references on most of these slides so that you'll be able to find this in tab 2, which has the petition, a copy of the petition, and also lots of quotes. And I tried to balance the denseness of the quotes by highlighting. So the petition talks about breaches of fiduciary duty by the individual directors, okay? And that includes not just Donald J. Trump, but Donald Jr., Ivanka, and Eric. And the petition says that the foundation operated without any oversight by a functioning board of directors. Decisions concerning the administration of charitable assets entrusted to the care of the foundation were made without adequate consideration or oversight and resulted in the misuse of charitable assets for the benefit of Donald J. Trump and his personal, political, and or business interests. And if you think about that paragraph, you'll be able to find breaches of the duty of care, the duty of loyalty, and the duty of obedience, all three of them, just in that one statement. The petition goes on in paragraph 31 to say that because of the lack of oversight and direction, Mr. Trump was able to use the foundation's charitable assets to satisfy the obligations of or otherwise benefit himself and other entities in which he had an interest. And we're going to get into some specifics shortly. Okay. So again, these are breaches of fiduciary duty by the individual directors. The board, and these are quotes, the board played no role in approving grants that the foundation has made and failed to obtain annual reports concerning the activities and operations of the foundation as required by the not-for-profit corporation law, specifically section 519. So this is one of those provisions that's mandatory under the law, and there's really no reason for a nonprofit to not follow. You're required to have an annual meeting every year of your members, and if you don't have members, of your board, and there needs to be annual elections for the board at that meeting, and significantly, you need to deliver the annual report with very clear and stipulated components and information that are set forth in 519. The foundation also failed to adopt the conflict of interest policy, even though New York law since July 2014, as you all know, required the foundation to adopt such a policy. See Not-for-Profit Corporation Law 715A, and you've got 715A in your materials. The foundation also did not have an investment policy, even though New York law required it to have such a policy no later than 2010. You've got a section reference there too. And the Attorney General notes that even though the foundation's assets, even in recent years, were over $1 million, they kept their funds in a money market account earning negligible interest. So, again, none of this is rocket science. Having an annual meeting, delivering the annual financial report, there's no reason for any nonprofit not to do that. Okay, so continuing in terms of breach of duty by the directors, making false statements in filings with the Attorney General. They really don't like that, and you'll see that in a little more detail shortly. Engaging in self-dealing, wasting charitable assets, this is a direct quote, or violating the Internal Revenue Code by, among other things, making expenditures to influence the outcome of an election. The foundation's directors failed to meet basic fiduciary duties and abdicated all responsibility for ensuring that the foundation's assets were used in compliance with the law. In representing clients who've come to me after they have been involved with an Attorney General enforcement action or investigation, and they're trying to get out of it, the issue of false statements in filings with the Attorney General and also a board abdicating its responsibility is a big priority for the enforcement people. We're going to, on this next slide, I want to unpack this statement a little bit and tie it into some of the duties we spoke about. So making false statements in filings with the AG, that's the duty of obedience. You've got a duty to follow the law. The law requires you to make truthful filings with the Attorney General, so that's a breach of the duty of obedience. Engaging in self-dealing, duty of loyalty. Wasting charitable assets, oversight, duty of care. Violating the Internal Revenue Code by making expenditures to influence the outcome of an election, that's the duty of obedience. And finally, abdicating all responsibility for ensuring that the foundation's assets were used in compliance with the law, that's oversight, duty of care, and again, compliance with the law, duty of obedience. So the Attorney General concludes that the foundation is little more than an empty shell that functions with no oversight by its board of directors. The foundation, which does not have any employees, delegated its operations to the accounting office of the Trump Corporation. So again, they abdicated their responsibility, their oversight, and they handed things off without supervision to Trump's business enterprises. Board members failed to exercise their fiduciary duty to provide oversight and control for at least 19 years. And Mr. Trump caused the foundation to enter into transactions in which he had a financial interest without obtaining authorization from the board or a determination by the board that the transactions were fair, reasonable, and in the foundation's best interest at the time of the transaction. This is directly from the related party transaction provisions of the Not-for-Profit Corporation Law. That's section 715, and you have those in your materials as well. And this is another omission that this didn't happen. Grants were made, expenditures were made, the board did not approve them. Therein again lies exposure for the board members who were not involved and basically abdicated their responsibility. And in addition to approving related party transactions, the statute requires, a not-for-profit corporation law requires, that the board has to make an affirmative finding. So it's not enough if the board unanimously approves a related party transaction. They need to do more. The minutes have to reflect that the board determined that the transaction was fair, reasonable, and in the foundation's best interest or the corporation's best interest at the time. So picture, and you've got this in your slides at 44. And you might want to, we're going to look at some detail. You probably won't be able to see it on the screen. So if you find it in your books on slide 44. So this is included in the section of the petition that talks about breaches of duty by the directors. And it's a picture of Donald Trump, then a candidate, presenting a check from the Trump Foundation. So if you look at the check, upper left-hand corner, it says Donald J. Trump Foundation with the address in New York City. That's appropriate. It's $100,000. It's paid to the order of a charity, Support Siouxland Soldiers. It's a veterans charity. And it's signed by Donald Trump. So far so good. But if we look at some of the rest of the check, you see the 5 stars on top. That's a logo of the Trump for President campaign. If you look at the bottom of the check, bottom left-hand corner, Trump in blue block caps is also a logo of the Trump campaign. Donald Trump for Vets.com is a campaign activity, a campaign organ that was part and parcel of the campaign. And finally, the campaign's trademark, Make America Great Again. So in this picture's worth at least 1,000 words. In this picture, you see the impermissible mixing and linkage of the foundation, which is a charitable foundation, and the campaign. So here we're going to discuss some examples of foundation activities, including what we were just looking at. So Mr. Trump's, and again, these are quotes right out of the petition with paragraph references, so you could find them and explore some more. Mr. Trump's political committee extensively directed and coordinated the foundation's activities in connection with a nationally televised charity fundraiser for the foundation in Des Moines on January 28th. And the disbursements of the proceeds from that event. And that's going to be something we'll talk about in a little more detail. In reality, the fundraiser was a Trump campaign event. The Iowa fundraiser was planned, organized, financed, and directed by the Trump campaign. At the televised fundraising event, the podium was decorated with a sign that borrowed the Trump campaign's themes and slogans. Donald Trump for Vets.com website was displayed on a blue placard with a red border and star pattern identical to the design of the campaign signs and billboards. Again, these are direct quotes. With Trump's name in capital letters and the campaign's trademark slogan, Make America Great Again. Following the Iowa fundraiser, the foundation ceded control over the charitable funds it raised to senior Trump campaign staff, who dictated the manner in which the foundation would disperse the proceeds, directed the timing, amounts, and the recipients of the grant. So in the testimony of the CFO of Trump's business entity, the CFO confirms that he used the foundation's charitable assets to satisfy the campaign's requirements. So this talks about testimony. So part of what the Attorney General's investigation entailed was subpoenas for documents, interviews, kind of in testimony and depositions of people involved. And also in the document review, interestingly, they talk in the petition about using metadata in the document. So when they forensically looked at documents, they went back and they looked at the metadata, and they pointed out in the petition how you could see through the paper trail, through the metadata, or through the electronic trail, that documents were generated by the campaign and not by the foundation. So during campaign appearances, Mr. Trump distributed the presentation copies of the foundation checks to Iowa veterans groups. So again, mixing the foundation's activities with the campaign, and that was an example of that was the picture that we looked at. The actual check, is the bottom bullet point, was sent by the campaign's chair, Mr. Lewandowski, from his address at the campaign, not by the foundation. So again, the campaign was running this from start to finish. At a At a campaign event 5 months after the Iowa caucuses, the charitable giving of the foundation again became the centerpiece of a political event. Mr. Trump promoted his candidacy by announcing the grants the foundation made to veterans groups from the proceeds of the Iowa fundraiser. The campaign slogan, "Here Too," was prominently displayed in connection with the announcement of the foundation's charitable giving. Mr. Trump reminded the press corps that he had raised millions of dollars for veterans at the Iowa event and took credit personally for giving out the funds, stating, and again, we're quoting directly, stating after reading out the names of each charity receiving a donation from the proceeds of the Iowa fundraiser, quote, "Nobody gave this kind of money, so I gave $5,600,000. Again, that just doesn't work, right? Because it wasn't Mr. Trump, it was the charitable foundation. And of course, Mr. Trump also challenged the press to compare his efforts to those of his political opponent. On or about the same day, the campaign posted on its website a chart identifying the recipients of the charitable tax-free grants given from the proceeds of the Iowa fundraiser and uploaded a news report. And the news report had a headline that said, "Lewandowski, Trump campaign gave between 5.5 and 6 million to veterans groups." So again, the mixture, the linkage, and the abdication by the foundation couldn't be more clear. So let's, I'll stop for a second. Anybody have any questions? Yeah.
David, this is perhaps a summary question for you, but since you asked, you've laid out a very compelling argument for the violations according to New York State law. A, what do you think the likelihood that the Attorney General will prevail? And B, what are the remedies that he can seek? Is it civil, criminal, or what?
So it's a very good question, and I think if it's okay, if we can answer it as we go forward, because I think you're gonna see some of that. So thank you. Yep.
What was the mission of this foundation?
Basically, it had a charitable mission sorry, the question was, what was the mission of the foundation? So to support charitable activities, and part of your requirements to get tax exemption are to be bound by the legal limits, both under federal law and state law, to not participate, two different problems, to not intervene at all. It's a blanket prohibition against intervention in any kind of political campaign. So you can't do any of it. That's number one. And number two, to not benefit insiders. We talked about that, no private enormement, using your charitable assets.
My question is not what you shouldn't be doing. My question is, we are all required to have a mission statement specific to what we do.
Right.
Did this foundation have a mission statement? Not what they did, shouldn't have done, but did they have a positive mission statement?
They did.
Charitable giving is not a mission statement. A mission statement of what your purpose is.
So
That should have been the first clue. That's my point.
right, and you know, when we looked at that picture of the check being presented by Donald Trump, we saw part of what the charitable mission was and what was appropriate, which was giving money to a veterans group. That was, by the way, now you can have a broader. I'm not sure exactly what the mission statement of the Trump Foundation was, what their purposes were in their certificate of incorporation, but you actually can have under New York law now, this is one of the convenient changes of the Revitalization Act, you can have a very broad mission statement that can be as broad as saying, and newly formed corporations generally at this point have this kind of a broad mission statement. Our purposes are any purposes that are acceptable under the law for a charitable corporation in New York. So that works. But by the way, even with that broad mission statement, you can't spend a dime on intervening in political campaigns or to benefit officers and directors.
Yeah,
So
I just want to know from a, I'm sorry, the requirements. I'm not talking what should have been done.
Mhm.
I'm talking about a statement of your mission. You give to children, your purpose is to give money to children. Your purpose is to give money to vets. Your purpose, whatever your mission statement should be clear, and everything else flows from that.
Exactly.
So it's not what you shouldn't be doing, it's what you should be stating. I want your mission statement for this charity.
Exactly. And well, so let's assume for the moment, and a lot of private foundations have a broad mission statement so that they could support, as opposed to public charities that tend to be more targeted. Private foundations tend to have broader mission statements, and the broad mission statement allows you to support charitable activities in a wide range of sectors. But again, that doesn't allow you to engage in some of these prohibited activities and expenditures. Yes?
So just to summarize what I'm getting out of it, it isn't that he isn't giving money. He is giving money to charitable causes. It's that he's not following the compliance issues. And he mixed the two.
Well,
It's not that he's a bad guy. He's giving the money.
well, that's so.
Let's face it, he is giving the money.
So two things there. Two things there, and so this is fundamental to all of this. It's not he's not giving the money. That's one of the ways he got in trouble. Okay, this is a foundation that's governed by New York law and federal law. The board of directors makes decisions. So it's not the Trump campaign that's giving the money. It's not Donald Trump. No, it's this charitable foundation. That's number one. And it's not only, and this we're about to head into this. It's not just the compliance issues in terms of intervening in elections. It's also self-dealing and related party transactions, and that's what this next slide is. And that's directly benefiting insiders, Mr. Trump, and his business interests. And so we're going to get to that. Okay, so you'll see this covered in paragraphs 72 to 90 of the petition, and these are self-dealing and related party transactions, and they're particularly clear and egregious. And this is going to get to the earlier question about how this is likely to turn out. So there was $100,000 given to a foundation. Now, that would broadly be consistent with the Trump Foundation's charitable mission. If we give $100,000 to a foundation for charitable purposes, that might work, except this $100,000 donation to a foundation was specifically to settle a claim by the city of Palm Beach against Trump's Mar-a-Lago resort. So that's a personally held business entity using foundation funds to settle a claim against that entity. $158,000 was given to a foundation to settle legal claims against the Trump National Golf Club. I think we all see why that doesn't work. A $5,000 payment was made to the DC Preservation League, a charitable organization for advertising space in charity event programs that was used not to advertise the Trump Foundation or other charitable endeavors, but in fact was used to advertise Trump International Hotels. So again, charitable funds that the board is responsible for preserving and using only for charitable purposes, used to advertise Trump International Hotels. $10,000 payment to a charitable organization for a painting of Mr. Trump purchased at an auction for that charity. So it benefited the charity, but the painting was used as decor at Trump National Doral, Miami, again, owned by Trump business entities. So in addition, a $32,000 payment to a land preservation charity that manages easements, here again, to satisfy a pledge made by a Trump business entity. Quote from the petition, the foundation's board failed to review or approve any of the above. So, you know, I want to tie this back to how a lot of nonprofits sometimes tend to operate. This is an extreme example, obviously, but it has our attention because of the players. So here you've got the board basically the board, meaning the three kids and their father, the kids trusted their father and said, he knows what he's doing, we can trust him, and they didn't pay attention. And I see this in nonprofits that get in trouble all the time. I see them relying on an executive director, a founder. I see them relying on people on their boards who are accountants or lawyers, who may not have a particular skill set that's needed in a certain area. As a director, and again, I commend to your review the materials in the binder, everyone on the board has an active oversight responsibility, and it's never going to be enough if something hits the fan to say, well, I relied on so-and-so because of so-and-so. That's just not good enough. It won't work. And now to the question of why I think the decks may be a little stacked in favor of the AG here in terms of how this is going to play out. By the way, a lot of these AG enforcement actions get settled because generally when the AG brings an enforcement action, and they spend 2 years investigating this, they've got a lot of documentation, and very often these don't get litigated out because the litigation may not turn out so well for the parties on the other side. So very often there are settlement agreements entered into, and maybe we'll talk about those at a future seminar because those are public documents usually that we can get access to. But after the commencement of the AG's investigation, basically when the AG started asking questions, reimbursements were made to the foundation for these improper payments. In addition to which, if that wouldn't in and of itself be something of an admission of impropriety, IRS Form 4720 was filed in connection with some of these transactions, and 4720 is a form to report excise taxes on improper self-dealing transactions. So those excise taxes and interest and disclosure, basically admissions, were filed with the IRS. So it's going to be pretty hard to sidestep responsibility for that, given that history here. Breaches of duty by directors. In 2016, the board knowingly permitted the foundation to be co-opted by the Trump presidential campaign, and thereby violated its certificate of incorporation and state and federal law by engaging in political activity and prohibited related party transactions. So as we said, under federal law, 501c3s are absolutely prohibited from direct or indirect participation of any sort in a political campaign, whether for or against a candidate for public office. And that prohibition is built in to the certificate of incorporation of every 501c3 because the IRS requires that to be in your certificate of incorporation before they will approve your tax exemption. So again, you're simultaneously violating both federal and state law, and you'll see that all over the AG's petition. So I want to make sure we talk about the role of the Form 990 in all of this. Question?
Question for you. Hypothetical. Supposing that one of the board members wants to get involved in political campaigns locally. You know, again, they didn't wear any paraphernalia that has associated with nonprofit. Is that a potential violation?
So this is such an important area that the IRS has put out wonderful detailed guidance on this. And I think they have, it's either 27 or 41 detailed fact patterns. And one of them, or more than one, touches on exactly that. So, and I think in the fact pattern, they may use a pastor of a church as an example. If you are involved on a personal level and not at all on behalf of the organization or involving or tying in the organization in any way, that's okay. We're not going to take away your First Amendment rights and your rights to participate in political campaigns. But you got to be really careful about crossing the line. So if you put it in your newsletter that, you know, executive director so-and-so or board member so-and-so, you know, or if you get up at a campaign event and tie your organization somehow to the campaign, that's likely crossing a line. So those are things they have to be very sensitive to. But the good news is that there's really detailed guidance on this on the IRS website. Sure. So this is a really important slide because, again, I want you to note this is a direct quote from the petition. And I want you to kind of focus on the reasoning here. Mr. Trump's wrongful use of the foundation to benefit his campaign was willful and knowing. And let's talk about, we're going to see what the evidence of why it was willful and knowing was. Mr. Trump was aware of the prohibition on political activities and the requirement of restrictions on related party transactions. What's the evidence of that? Among other things, he repeatedly signed under penalties of perjury, IRS Form 990, which, by the way, says that you're signing this under penalties of perjury, in which he attested that the foundation did not carry out political activity. Mr. Trump also signed, again under the penalty of perjury, the foundation certificate of incorporation, in which he certified that the foundation would not use its assets for the benefit of its directors or officers, and that it would not intervene in any political campaign on behalf of any candidate. So the Attorney General is saying in the petition that these violations were willful and knowing, and that Mr. Trump was aware of these prohibitions because he signed the 990 and because he signed the certificate of incorporation. So again, when I have clients come to me when they've got a problem, I very often hear from them, well, the accountants and the executive director prepared the 990. They said it was good and I just signed it. That rationale is not going to get you anywhere, because as you can see here, you're imputed to have knowledge, and you're imputed to have done things knowingly based on that signature, and it's never going to get you out of the line of fire to say, I relied on other people. Similarly, you've got the three children, Ivanka, Don Jr., and Eric, who clearly had nothing to do with any of this, completely ceded their responsibility, relied on their father, and they are totally in the line of fire. So also 990 problems. There was some funny business, and I won't get too bogged down in it, but you can look at paragraph 66 and 67 with respect to disclosing the recipients of foundation grants. In one instance, a grant was made to a political organization, but they listed as the grantee a non-political organization that had a similar name. And the petition comes to the conclusion that the foundation has no credible explanation for the false reporting of grant recipients to the IRS and New York State. And remember here, and I think, do we have a question?
People ask me questions. For some reason, the webinars aren't hearing it. Can you just repeat the question?
Sure, will do. Yep, thanks, absolutely. So note that the 990, which is a federal document, this is a pretty fundamental point, but it's implicit in all of this. It's attached to your Char 500 filing with the New York State Attorney General's Charities Bureau every year. And so even though it's initially a federal filing, it becomes a state filing because you're filing a copy of it with the state. And so who uses those 990 disclosures? Pretty much everybody, funders, donors, potential board members, the press, people with grievances against the organization, sometimes disgruntled board members, disgruntled members, members of the public, and significantly regulators, the IRS and the Attorney General's Enforcement Section. The Attorney General's Enforcement Section has a dedicated unit that mines the 990 disclosures for red flags. Yeah, question, which I'll repeat.
Yeah, I have a question. The political campaign is over. He's now president. If he continues to use his name on everything, is it still political activity, or is it only during a campaign?
So his name is distinct, certainly, from the name of the foundation, and it's the Donald J. Trump Foundation, and that foundation exists as an entity, and it's governed by its board and has to follow all these requirements. Donald Trump as an individual can do whatever he wants. But the problem is, and remember that picture that came right out of the Attorney General's petition, that's actually embedded in the petition. You'll see it. And that picture shows how those things were mixed together. So it's fine for Donald J. Trump, president, leader of the Republican Party, to be as political as he wants to be. But he can never involve the 501c3 foundation in any of that. And that's where the problem is, mixing the two. Did I repeat the question or I didn't? Yeah, okay. Sorry. Okay, another question.
Hi, David.
Hi.
I have the stack of 990s under my desk, as I'm sure you would know that. Mm-hmm. Every one of them is signed by an accounting firm in Woodbury. How much trouble is he?
So that's interesting, it's not. It doesn't give me particular solace when when I'm representing a board that the accountant may have some issues. One of my slides, which we won't get to, but I'll highlight for you, it's slide 71. I invited the two section chiefs of the enforcement section to a meeting of the State Bar Association Committee on Nonprofit Corporations. And one of their slides, and I can repeat this because it was a public forum, so one of their slides said that we, from the Attorney General's perspective, are starting to ask, and this is right off the slide, a new question: where are the auditors? And they were saying that that in instances of significant improprieties at nonprofits, inevitably the auditors have dropped the ball, and that they're starting to focus on that from an enforcement perspective more and more. And there's the National Leukemia Foundation, which is mentioned later in the presentation. That's something you can look at the website, on the AG's website. They also, in that instance, focus on the 990s, and they talk about how the 990s, which had false and misleading information, were made available to the public through the Attorney General's website. And so basically the auditors and the board, by filing the 990 with the state, involve the state in misleading the public. So I'm gonna have to wrap up. I think we covered most of what I wanted to get to. I wanna maybe just hit one piece of remedies. Basically, towards the end of the petition, the AG concludes that there were breaches of the duty of care, loyalty, and obedience, and I think that's clear from the facts that we went through. The section that they reference, 720A, is in your materials. Due to the foregoing acts and omissions, the individual respondents, including all of the directors, Junior, Ivanka, and Eric, the individual respondents breached the fiduciary duties they owed to the foundation. They are thus liable under Section 720 to account for their conduct in the neglect and violation of their duties, and to pay damages resulting from loss and waste of corporate assets. And in addition, they should be enjoined from serving as an officer, director, or trustee with any nonprofit that is allowed to solicit funds in New York State. And similarly, on the next slide, talks about restitution and damages. And Donald Trump himself is asked to pay to the extent double the value of any. There's a provision in the law that allows double the value of any benefit improperly obtained. And the last thing I'll say to you before I hand it back to Ken is that very significantly, and this ties into what I've been saying all along this morning, simultaneous with filing this petition, the Attorney General sent a letter to both the Internal Revenue Service and the Federal Election Commission referring this matter to them. And I should note, and this was in partial answer to a question earlier about the penalties. The financial penalties are significant under the not-for-profit corporation law. They are even more significant under federal election law and the Internal Revenue Code, and they can conceivably include not just financial penalties, but possibly for false filings. There's some possibility of criminal penalties as well, which may not be so relevant here, but it may be relevant for directors of nonprofits that you may be aware of. So on that somewhat ominous note, I thank you, and I'm turning it back over to Ken.
Thanks, David. David said a lot of things. What I took out of it is make sure you use the right accounting firm.